Hello, I'm Maria Ressa. It's been a year since various groups petitioned against the cybercrime law because of its controversial provisions like the clause on online libel and the takedown clause, which allows government to block access to online content even without a court order. The Supreme Court hasn't decided on this law after temporarily stopping its implementation, but we expect a decision soon. Attorney J.J. Decini is one of the petitioners. He's one of the country's top IP lawyers. He joins us today to talk about why this is important and what does it mean for Filipinos. JJ, thank you for coming to Rappler.
Yes, thank you.
And full disclosure, JJ is one of Rappler's retained counsels because he's one of the best. Anyway, JJ, so what is this? Why should people care about the cybercrime law?
Well, the big issue, of course, in many people's minds is the provision on libel. So people are concerned about many things that they do online. They post many things. People are very opinionated online, and sometimes they rub people the wrong way, and they don't want to be at the wrong end of a libel suit. So we've seen many instances where even just a Facebook status post can lead to a libel suit. So I think that's one area where people are concerned. There's a freedom of expression issue. But other than that, there's also a provision for double liability in the Cybercrime Prevention Act. It says that even though you've been charged with libel under the revised penal code, you can be charged again for online libel under the Cybercrime Prevention Act, and then you will be charged. You're open to a greater liability in the Cybercrime Prevention Act. So it's double liability. So something like libel can get you as much as 10 years in jail, well, at maximum. So it's one of those things where now you're violating the right against double jeopardy. So you're supposed to be protected against double jeopardy. So these are constitutionally protected rights. And then there's the right to privacy. The Cybercrime Prevention Act allows the police authorities to monitor your data traffic without securing a warrant. In fact, without getting any warrant at all, or even reporting the matter to any judicial authority. It is merely on their own authority that they can engage in that kind of surveillance. So I think that violates the right to privacy. And then, of course, the takedown clause, which even the Solicitor General did not want to defend and admits that it's unconstitutional, allows the Secretary of Justice to take down content upon a mere complaint, a prima facie finding. And then so that when you tie that up with something like libel, then you're talking about, again, freedom of expression and the ability of a Secretary of Justice to censor, to become a censor, so to speak, of any content that appears online. So these are fundamental rights that we care about, and if we care about them, then we're concerned about that these rights are being infringed as we interact more online.
So it seemed that there was no argument that there were parts of the law that was flawed, but let me be devil's advocate.
Yes.
Isn't there some need to try to control what comes out? Online libel, for example.
Yes.
There are lots of things people write that isn't true or is libelous, but there are no laws to really deal with it. Where should we be heading with this?
Okay, so actually on the issue of libel, Professor Harry Roque was the one who took the lead on the issue of the constitutionality of libel itself, whether libel should be decriminalized, and he took the position, I think, consistent with the views of the United Nations, that libel should be decriminalized and be turned into a civil action. So if you want to hold somebody liable for libel, you just file a civil suit. Don't throw them into jail. Precisely because there are concerns about not only freedom of expression but also freedom of the press. In many instances, it's actually the media that are the targets of libel suits. And even though there's case law that gives media personalities or the media outlets, for example, a good defense. Now, this is the New York Times versus Sullivan decision. What happens locally is that even though this protection is there, the criminal case is still filed, and the journalist still has to bring up that defense on their own. So there are many cases out there where the intention of the public figure who is attacked is not really to protect his reputation against libel, but really to stifle any public discussion of issues that are being discussed by the journalist in that particular libel suit.
And with something like this, what are the safeguards now for people like that?
Well, the safeguards are there. Unfortunately, enforcement has been sort of spotty. So let's say that a media outlet says something negative about a public figure. Now, under the New York Times versus Sullivan rule, unless there's actual malice,
Yes.
the personality, the public person, will not be able to file the criminal case against the media outlet. What happens here is that there is a preliminary investigation conducted by the prosecutors, by the fiscals. And if they find, and a lot of them do, they figure it's not our place to determine whether or not this defense is available. It's up to the courts to determine that. So they file the case, and a warrant of arrest is issued against the defendants.
Right.
And then it's up to the media outlet to defend itself in court. Now, in a situation like that, certainly it becomes a deterrent. Now you don't want to. Now when the next story comes in, you may not want to bring the story to the public. And when it comes to public figures, there's a public interest, public discussion of matters of certainly things like governance, for example, are important for a well-functioning democracy. So it's important that we protect these rights, and criminalizing libel challenges those rights. So in that very true sense, there is a need to sort of decriminalize libel. And so that's one option that the court sort of left open. It's a possibility. The court might actually come back with a decision and say libel itself is unconstitutional. What that means is that all libel cases that have been filed, that are in the courts right now, will be dismissed.
Right.
All people in jail who possibly who have been convicted of libel will be set free. So it's possible that the court decision can be as far-reaching as that when it comes to the area of libel.
You've been watching the way the proceedings have gone. Aside from this, what other ripple effects do you expect from this decision?
So that would be a big win,
Huge,
I think.
actually.
A huge win. I think particularly for freedom of expression.
Right.
So, I mean, we've seen even after the Cybercrime Prevention Act, TRO, was in place, the cyberperling case shows us that journalists are still, or in that case a blogger, but still a media outlet, covering public events, covering public figures, are still under threat of libel. So the court decriminalizing libel would be a huge win, not only for freedom of expression, but particularly for freedom of the press. And I think, I think to a large degree also the PNP might and the NBI might heave a sigh of relief in that a lot of their cases now will be dismissed, because it seems that they field a lot of cases involving online, so Facebook type libel. So those cases presumably will go away if it's decriminalized, and now it's a civil suit. So that would be better.
What about the actual proceedings? Anything stand out from what you've seen?
Just going back, one of the things that have happened, and I know this is, I guess I can't say this without sounding like I'm promoting myself, but one of the things that happened while this case was pending was the Supreme Court adopted a new rule.
Yes.
It used to be that the first person who files the case gets the title of the case. This case is now, initially was titled Biraugo versus, I think, the Secretary of Justice. But I think there have been so many cases where Mr. Biraugo was the first to file.
Yes.
And so the Supreme Court changed the rule, and what they do is they look at the petitions and they say which is the weightiest, substantial, brought the most substantial arguments, and then that will become the title of the case. So what happened here is that our petition, although we were third, was selected by the court. So now it's Dicini versus Secretary of Justice. And if that is any indication, then I would think that the issues that we raised were certainly, there's some preliminary determination by the court that these are the weightier issues. And these are the issues I discussed earlier.
Yes.
Yes.
Online libel, freedom of expression issues, double liability, the right to privacy,
Right.
the takedown clause.
Yes.
Can I just focus on the right to privacy?
Yes.
The way you said that it would monitor data traffic without any
a warrant. Yes.
If you're talking about data traffic on social media, for example, isn't that out there? Isn't that open to the public anyway? People have pushed it out to the public. Couldn't that be monitored by anyone?
That's
Just
interesting. I
being
never really
devil's
thought
advocate.
of and I never really thought of what is data traffic when it comes to social media. So in other words, I could see your likes.
You could see the post, you can see who you're talking to.
Okay. Now, data traffic, as contemplated by the law, would cover that, but that's already publicly available.
Yes, correct.
Actually, there are services that are available that you can subscribe to. These are pay services, as far as I know, and I can use that, and I can see all your social media. I can go to a person's, enter that person's email, enter his Facebook account, and I'll see whatever he's done online. That is publicly available.
Right.
So that information is already out there.
Right. That
Data
digital
traffic,
footprint.
right.
Yeah.
The data traffic that the law contemplates are things like the law enforcement agencies can go to your telco and say, here's Maria Resa's number, and who has she called? How long have the calls been?
Yes.
And when were the calls made? Incoming, outgoing. They don't know, they cannot tap, they don't know the content of the conversation, but they would get all that information. They can even get information about who's texting you and who are you texting. So the numbers.
That's incredible.
And it may not identify who these people are, but there are very easy ways, you can just even pretend to be a wrong number, right? You said, oh, I'm sorry, I got your number from Maria. Who's this again? And then you can get that person's identity. So you have data traffic that can very easily turn into actual information, right? Supposedly anonymous information, and not really public information, because this is information that only the telco knows.
Yes.
So things like what happens within your own IP. So you have an internet connection at home, you have a DSL connection. What IP addresses are you going to? What are you visiting? How long are you staying at those sites?
Correct.
What are you doing?
That's scary.
That's scary.
NSA.
Yeah.
Here you go.
Well, they're doing it already. I guess that's your point.
Exactly. Right. Well, there's some questions coming in from social media. From Lamberto Laparan Santos. Other countries have their own versions of the cybercrime law. Would it be disadvantageous on our part not to have one?
So he's correct. So there is the EC Council of Europe Cybercrime Treaty, the Budapest Convention, upon which we based our law.
Yes.
And certainly we want to be part of that convention because there are international cooperation obligations. So it would be easier for Filipino victims, to seek assistance from law enforcement agencies all over the world that are part of the convention.
Yes.
So that would be very helpful. And actually, this is one of the bad things that the TRO has put in, that these provisions have sort of been have been suspended. Some additional authority on the part of law enforcement officers to get a search warrant to look at content, for example, or get subscriber information from the telcos. These are important rights authority, right, or powers that can be given to law enforcement agencies that are in the Cybercrime Prevention Act. So I do agree that we do need a Cybercrime Prevention Act. I do agree that law enforcement should be given more authority to investigate. These are different types of investigations that do not necessarily go into physical spaces, but go into sort of the electronic realms but actually reveal a lot more about people than visiting their physical space.
Right. Another questions from at Air Kurkuran Rowan, Rowan. With evolving technologies that emerge every 3 to 6 months, how do you think the cybercrime law will be able to catch up?
Well, the provisions that we took from the from the Cybercrime Treaty are very broadly worded. So they are sort of quite technology neutral. So I think they should be enough. And if something new comes up, then we can go back to Congress and have an amendment. So I don't think that's...
In the earlier question, the government has recently said that cybercrime, for example, child pornography on the internet, part of the reason they can't move on this, and there was a recent arrest of Australians here in the Philippines, part of a global ring. The PNP has said that this is thriving in the Philippines, and part of the reason they can't stop it is because we don't have a cybercrime law. What's your reaction to that?
Child pornography, actually, if you look at the Cybercrime Prevention Act, there's a provision for child pornography.
Yes.
But it really didn't say anything. What it did was it referred back to the child pornography law that we already have.
Correct.
Which means that the child pornography law, yes, is already sufficient. I mean, Congress has already made that determination, and online child pornography is already punished under that law. So it's a nice thing to say. I think perhaps the law enforcement officers might have been quoted out of context. I think what they probably meant was it's more difficult for them to investigate these instances, because one of the major hurdles for law enforcement agencies is getting the cooperation of the service providers. The Cybercrime Prevention Act would solve those problems. And certainly, well, my petition does not question those provisions. Other petitions do. So some petitioners have questioned the entire law, and those are under threat of being stricken down. So I feel like my petition is sort of taking the middle of the road sort of compromise, where we save some and then we take out the bad parts.
Yes.
Yes.
What's your best case scenario for this decision? What things do you want to see happen?
Me? Well, of course. That's a very good question. I think that it's good for the court to. I think it would be good if the court takes out libel altogether. So they render it unconstitutional, and they invalidate all other previous convictions or set people free, right?
Yes.
Who are now in jail for libel, and then dismiss all those cases. So I think that's a good thing if they do that. That would do wonders for freedom of expression and freedom of the press. And of course, I mean the provisions that I've mentioned, I'd like to see them all stricken down. There are a couple of provisions actually that I'm concerned about, that I don't think necessarily there are constitutional issues, but they're not very well worded. And this is the provision on cybersex and the provision on domain names. So there's some, even the provision on identity theft. These are, especially on identity theft, the provision is quite vague. And also the provision on cybersex, where it seems that you only punish the person to whom consideration is given, but not the person who's giving consideration. So it's sort of one-sided. It sort of punishes only one party as opposed to both. And it seems to me that if both parties are consenting adults and they are engaged in a one-to-one how do you call that, interaction, right? Yes. Of that nature, why should it be
only one?
Why should it be why should it be a criminal offense if it's between two consenting adults? Right?
Okay, interesting.
So there's that issue, right? It's not pornography because it's not one to many.
Yes.
The big issue there is the exchange of money. If I exchange money with you for you to do this, is that a crime? Where there's no physical contact. I think that's the challenge really in cybersex.
So interesting.
Right.
Prostitution, I guess where's the line with prostitution and something like that, right?
There's no prostitution in the sense that there's no physical contact.
Right.
Right. So I mean,
sex services though, it's still right.
I guess it would fall under that category. But I think the big question is if the social harm is there. Right? Certainly, compared to prostitution, this is better in the sense that there's no physical contact, and that there's actually there's money to be made, but there's less risk. But I mean, you could argue also that kind of cybersex leads to other crimes, leads to things like human trafficking, leads to things like may lead to pornography, may lead to other things. So you can say it's an entry crime that let's penalize it now so that we can prevent further problems in the future.
So if once the Supreme Court decision is out, they rule on provisions of the law, what happens next?
Well, the TRO would be lifted.
Okay.
There will be, presumably...
If they rule against the law, will the law have to be rewritten?
If they rule against the law in its entirety, then you were back to square one. We're back to the E-Commerce Act as the cybercrime law that we have, and Congress would then need to reenact a Cybercrime Prevention Act. There are already bills. The DOJ already filed its amended cybercrime law, and I think PIFA, that's the Philippine Internet Freedom
yes, they have the
Alliance.
NCPIF, right?
Yes,
a crowdsourced
the crowdsourced
internet cybercrime law.
It's a pretty, not just cybercrime, but it's everything.
Yes.
I forget what they call it, but it's actually quite a heavy piece of legislation, because it covers not only cybercrime, but sort of all other related issues. It covers privacy, it covers telecommunications policy, it covers open access, open data. So it's a lot of things, and it's quite difficult actually. From a strategic standpoint, it's not likely to be enacted because when you have a piece of legislation that affects too many things, then it's easy to strike it down. I mean, to block it in Congress and say there's a group that's
working on
that's
this
working
or
against
that has this.
Yeah, they're only concerned about one part of the law, but they'd rather see the whole law not pass through. Whereas if you just stick to cybercrime, then you know it's a specific sector and you can limit the exposure. And therefore, you minimize the chances of opposition coming from different sectors.
So this is if they strike the whole law down. What if they just say online libel? What if they only make a decision on one part of it? What happens next? Will the law continue? Will the
Yes.
TRO just be lifted?
Yes, there's a separability clause. I
Okay.
think Senator Angara was quoted in a news article I think at the beginning of this week, saying that there is a separability clause. If one provision is considered invalid, then the rest that are not invalid will continue. So that's actually the approach that I've taken. I have 4 things that I'm concerned about. Strike those 4 down, and then let the rest through.
There's something else that did pass, though, right? This Data Privacy Act. Isn't
Yes.
there a Data Privacy Act? And has that, you were very alarmed about that
Yes.
to begin with. Has that been implemented in any way? Has that been
Currently, it's what's the word? It's in suspension because the law. Well, to a certain degree, there is a provision in the law that says that implementation by existing businesses of the Data Privacy Act will only happen 6 months after the implementing rules are enacted. And the implementing rules cannot be enacted unless the Data Privacy Commission, National Privacy Commission, can be constituted. And the President has not named the chairman
Oh my
and the
Lord.
2 commissioners, and it's already been...
But that's still a law that's problematic. Is that correct in your mind?
It has a lot of provisions. There are compliance issues for many types of entities. Fortunately, there's a blanket exemption for journalism. So if you're going to use private information for journalistic purposes, it's exempted from the law. And so, but I think it's more of a compliance issue for a lot of online businesses and a lot of real world businesses, including marketers. So if you're engaged in data mining, you engage in big data, depending on what you're doing with the information, you might be affected by this. So let's say you're a bank and you're going to use big data in order to try to provide specific types of services for a targeted audience based on what you learn on big data. You need to check your process to see if you're coming to terms with the Data Privacy Act.
It's so interesting. The law was created before the big data has actually even been implemented efficiently, before the uses have been found.
Right.
So let me ask you, we talked about what happens if parts of it are struck down. Is there any chance that the TRO would just be lifted, that the Supreme Court will say there's nothing wrong with this?
Yes, I mean anything's possible. Certainly, the Supreme Court can say in its entirety this should be upheld. I'm sure it's happened before, where a law has been challenged and the Supreme Court refused to take the view of the petitioners.
But given the way the arguments have gone and the
Yes.
Supreme Court, do you think there's a possibility that?
Well, I think Section 19, the takedown clause, there's no question. I mean, if the Solicitor General himself said that it's unconstitutional, then they've basically given up on that issue. So at the very least, I think the court will agree. It would be very strange for the court to take a position contrary to the parties. Both parties have come to the court saying that this is unconstitutional. Although it's not impossible. The court can say, well, we take a different view. But if you ask me in terms of odds, I would think that, as in many things, the middle road is actually the usual path that's taken. And I think the middle road is strike down some, keep the rest. So it's just a question of, I think it's just a question of how much.
A question from social media again, Neil Lacuna Pagalaran. What's a better alternative for this frozen law given that cybercrimes like skimming, identity theft, credit card fraud are at an alarming state?
Okay, so credit card fraud is covered by another law. That's RA 8484. That's Access Devices Regulation Law. So they can take a look at that.
So this
skimming,
has no
skimming,
effect
as I
on that.
understand, is taking the magstripe data,
Yes.
right?
Yes.
So that's credit cards are known as access devices. So if you make fake access devices, if you're in possession of tools to make fake access devices, you can be charged under that law. So my understanding is that I think the PNP sometime this year, how do you call that? They went against or had an operation against a group that actually traffics in this kind of data, and they charge them under this law.
Is it is this law written well enough to anticipate the technological changes that are happening? This is a question earlier on.
Okay. So, I mean, so this law, a lot of it is based on the Cybercrime Prevention, the Cybercrime Treaty, which is an international convention. And in that sense, whenever we copy from a foreign source such as that, we actually end up with better results. Because they think it through. The people who write it think it through. So when you look at, and I think the Chief Justice during the oral arguments hinted at this, that when you look at the provisions of the law, the provisions that copy almost verbatim the Cybercrime Treaty, those provisions are okay. When we started adding our own provisions, such as the one on domain name, such as the one on cybersex, and the one on identity theft, that's when the language becomes loose and difficult to implement and sort of difficult to understand. And so there's a wordsmithing issue, I think, with respect to the Cybercrime Prevention Act. Myself, I'm not comfortable with these provisions, but I didn't think they were unconstitutional, but it's entirely possible that the court could strike them down. And certainly I think that there's some recognition that the quality of the crafting of the provisions went down, dipped when it came to sort of local crafting.
One of the things that isn't covered in this law is cyberbullying, but it's happening and people globally are really concerned about it. In fact, I don't think we really have a definition for it yet in the Philippines, although we've had instances. One of the guys who really talked about this is Chris Lau.
Right.
He claimed he was cyberbullied to the point that he thought about committing suicide. How do we deal with something like this?
It's a difficult problem. Bullying itself is a big issue. Even just real world bullying. Cyberbullying is a new phenomenon. And I think in some places it's a crime. I mean,
it's a crime in the United States, yeah.
The big issue is, what do you do? And how do you prevent it? So in the case of Chris Lau, he gets attacks from people he doesn't know. He gets emails from people. He gets comments. So one of the things that you can do is you can shut that off. To the extent that that's possible, I'm not sure. So you sort of take a digital vacation and say, I'm going to shut everything off. I'm going to go in airplane mode, and I'm not going to listen to any of that. I think the issue is with respect more for minors, where they are more vulnerable. And I think perhaps the better thing to do is not necessarily to make it a crime, but to give assistance and give people coping mechanisms to deal with that. Of course, I think that it's important for people who see this happening, so from a societal level, to sort of make it socially unacceptable to engage in that kind of behavior, to tell people, stop that. That's no good. So I'm reminded of a time I attended a baseball game in the U.S. And I'd heard about the soccer matches in Europe where people go crazy. The audience are separated by chain link fences, but despite that there are riots. And what happened was, we were in a group, and there was somebody who said something very negative about the opposing team, and as a result, there was a gentleman who stood up and talked to that guy and said, you're not supposed to do that. So there are very strong norms with respect to baseball games, right? They said you're not supposed to, slam the other team so much. So what I'm saying is that societal norms can solve the problem of bullying if bullying itself is considered to be something that's negative and something that needs to be addressed.
It's really hard because, again, if somebody's trying to intimidate you, where does intimidation turn into bullying, and then where does the cyberbullying mean that when the hive comes at you? And it's a tough thing, but they have criminalized it. I mean,
right.
in the
the tough thing is that if you're the victim of bullying, oftentimes you have nowhere to turn.
Correct.
It's even socially unacceptable for you to turn to someone.
Right.
Right. So if you're a kid and you're the victim of bullying, if you tell the teacher, it just seems you've broken some code,
Yes.
right? That you're not supposed to talk about those things. But it's a sort of this sort of code is what allows bullying to perpetuate itself.
So in this, without any kind of laws or even definition in this country, we don't have anyone to turn to if you're cyberbullying.
Right. So I'm saying maybe society itself, we can create norms around bullying and say and stop each other.
Yeah.
Right.
That's
we say
that's what we
bullying,
wind up
stop
saying.
that.
Yes.
So what I'm
Yes.
saying, perhaps that could be
Change
something
the
like
norms.
an NGO, or that could be like a
NGO for social media.
a social, I mean, it's like a ribbon for AIDS and
Yes.
whatnot. So these are changing social norms and views about changes that we see in society. And I think that's what we need for cyberbullying. I think that would be more effective than saying it's a crime, because
Yes.
then it could still happen and people will just do it anonymously.
Oh, it's
Because
so
and that's the
interesting.
reason why they do it anyway, because it's anonymous.
Correct.
Right?
Correct.
Right. So unless you have less anonymity, it will continue. Something that happened to Chris Lau will happen.
Well, there are also the studies that show that the way social media is set up now is it bypasses certain of your own defenses because it's much more emotive. It's fascinating, the stuff
Yes.
that's there. Let me go back. There's several questions now, and let me pick this one up from our head of investigative from Chai Hofilenya. She's picking up on what government can do without the cybercrime law, and she's asking on investigations by the government, if they obtain the necessary permits or warrants, will these be more acceptable?
So the answer would be yes. But I think the challenge for the NBI and the PNP now is that when they go to the court and say, we want a warrant for a particular type of, say, online surveillance.
Yes.
Typically, by the time the court gets to that warrant,
It's done.
it's
Yes.
And the related problem is, so you can ask the telco to say, hold the data. We're not asking,
Yes.
we're not getting
Yes.
it yet, but give us a chance to go to court to get it. And in many instances, the telcos will not heed that call. So there's that problem for the law enforcement agencies, where they want to get the information, but it's not preserved in time. And the Cybercrime Prevention Act will make these sorts of things very explicit. That the PNP can say, hold that data for 6 months, and then they can extend that period while they're waiting for a court order to come through. It's a bit like the authority of the Anti-Money Laundering Council.
Yes, yes.
Within a very short period
Yes.
of time, they can get a
You
freeze
get it right
order,
away,
right?
yeah,
So like
yeah.
1 or 2 days, you have the freeze order in place, and then you have a 6-month period where you can go to a lower court and prove sort of
Yes.
at the pace of the judiciary, so they can come up with a more permanent order.
This is the last question from social media from @Audiru, and this is going back to libel, which is kind of how we started the program. Won't decriminalizing libel make people less reluctant to commit it? I think it means if we decriminalize libel, will it happen more often?
So the answer, I guess, would be, from an economic standpoint, right?
Yes.
When you take out the disincentive, then the people would actually do it more. It's criminalized now, and people are still doing a lot of it.
Yes.
Right. The larger question is this? So it's a balancing act. No? Should we allow people to charge or to put other people at threat of jail for libel at the cost of seeing freedom of expression at stake, or freedom of the press?
A chilling effect on the
those
media.
rights.
Yes.
And one-to-one discussion, that might be libel. It might be a crime. Yes, but if we're going to maintain it as a crime, and as a result, I cannot speak out publicly on issues that are of great public interest.
Yes.
Because I might be under threat of libel, right? I think these sets of rights are weightier than the private claim to libel. And certainly, we're not saying there's no redress. We're saying,
Yes.
let's make it a civil suit.
It's so funny because this is actually already a societal reaction to a law that existed, right?
Yes.
Before, it was civil crime. It wasn't a criminal law, and then people felt that there were still too many libel cases, and so they thought it would have a more deterrent effect by making it criminal. You remember that? I remember covering this when it became criminal.
I mean, online.
Yeah, not even online, but normal libel, like libel in general.
Yeah, I think the standard argument is that globally the trend is towards decriminalizing. I
Yes.
think we're one of few countries that keep it on the criminal books. or keep it a crime. So there's that thing where should we follow the global trend?
Yes.
It's certainly that argument. And the UN has already determined that that they believe that it is consistent with our obligations to the United Nations Charter on Civil and Political Liberties that libel be decriminalized. So if these things are going to be consistent, if we are going to be consistent across the board, then as a modern society, I think perhaps that is the decision we need to make. And if it's at the cost of people getting hurt online because things are being said, then you know, I say you can go to the courts.
Yes.
Right.
Well,
but in many things, you know, what I find about online libel is that people get very upset for a period of time, but then after there's a 48-hour time period, I think, where there's times when I tell people, I know you're upset, but you know, sleep on it, give 48 hours. If it still is a good idea to file a case or do whatever you want to do, then go ahead. And in many instances, these things are just because when you file a libel suit, you are perpetuating it, right?
Yes.
Whereas if you ignore it, then after 48 hours, people's attentions are on something else.
Yes, yes.
Right?
And you brought this up as a difficulty here. I mean, in general, from probe days when I was younger, people really who didn't want you to write about them, who didn't want you to expose them, would just file a libel case to try to either intimidate, harass, or if you're a small company, which we were in probe, Newsbreak as well, to try to bankrupt you.
That's right.
Filing the going back to it. Didn't work then, but this seems like a whole new ballgame. Let me go to something we didn't discuss at all, which is cyber espionage.
Okay.
From the NSA and the Snowden documents, we know for sure it's happening. Do we need legislation for it?
We can legislate all we like.
Yeah, it's going to happen anyway.
It's going to happen.
Right.
It's going to happen because, the only way we can prevent that from happening is if the Philippine consumer or the Philippine government says that mandates that traffic within the Philippines, for example, is kept in the Philippines. So if I'm going to send an email from somebody in a PH domain to another PH domain,
yes,
then it does not leave. It does not go to the United States.
Yes.
The problem now is that since we have the ISPs and the telcos are connected to not necessarily to each other, but certainly have stronger links to international peers.
Yes.
Then what happens is if I send an email from say my domain, which is dcini.ph, to Rappler,
correct,
it goes more often than not. It will go say to LA,
correct,
and then go back. It's when it enters the US
that it's
and it will usually enter the US because the fastest traffic goes to the US. What happens when I press send on my computer is that at that moment the software asks, what's the fastest way to send this? It queries the system, and more often than not it will end up in the US. And apparently the US have determined that even for things like voice traffic, this happens also, but not necessarily here. So the US is uniquely positioned to get this information. And since they don't require warrants for surveillance on non-US citizens, then the NSA is free to look at. And I would assume that they are looking. But it's not as if it's individuals looking. I think a lot of it is automated. When issues are flagged, then it goes to an analyst, and then somebody will read your emails. And if they feel that there's some concern, they might tap your social media, all your social media accounts to track who you are, if they think you are a risk to them. And certainly the issue here is terrorism, right? And I feel that I think they believe that they need to do this to prevent an attack such as 9/11.
Yes.
And certainly they credit themselves that no such attack has been repeated in the US since 9/11, simply because they've taken these measures.
Right. So the closing thoughts here is going on that global thing. There are so many other crimes that didn't exist before. Anonymous hacking, taking down data, Chinese espionage, the kind of proxy wars that are going on between China and the United States, Iran and the United States. Where do we stand in all of this? How prepared are we? Will this law make a dent in any of that?
So surveillance and espionage, I think, will happen. Commercial espionage will continue. So the Cybercrime Prevention Act will provide some sort of protection if you can prove it. I mean, that would be a situation where the people conducting the espionage would not be very good if they are caught. But certainly the Cybercrime Prevention Act could help people who are victimized by that kind of action. Now, if it's against a government, it would be very difficult, I think, to bring a criminal case against a government. Certainly if they're doing the surveillance from their own facilities. So the ability of the United States to look at even the president's email. I mean, we have government agencies that use Gmail.
Yes.
Right? If you check their email accounts. And so what that means is that Gmail is in a position to know, Google is in a position to know, and Google has already demonstrated that if asked by the US government, they will surrender data. And that's without even considering that the US government itself might even be connected to the telcos directly, that they may already be scraping that data, just as a matter of course.
Yes.
So it's a very difficult problem, and there's no easy solution. But I think the Philippine government, if it wants to protect itself, they can institute policies, certainly within the government, to say, look, if you're going to send an email from .gov to .gov, then it stays within a closed system that does not leave the Philippines.
So let's go back to the Supreme Court ruling that we're all waiting for. I asked you your best case scenario. In asking for your worst case scenario, I guess I'll also ask you to evaluate, is the Supreme Court tech savvy enough to actually look at all of the different dimensions of it? Because certainly the drafting of the law seemed to miss many points. Do we have a savvy enough Supreme Court, and what is leading to that? Your worst case scenario, what will you do?
We'll file a motion for reconsideration.
You do it again.
Right. When the oral arguments happened last year, and I was looking at the justices, and my assessment is that certainly on issues of constitutional law, all of them are well versed.
Yes.
On the issues of technology, there are varying levels of understanding. But I think there are enough members of the court who understand the issues, and even those who are less knowledgeable, even though they don't understand the specifics of the technology, they can still see how the technology works to the point that it affects fundamental rights. So I'm not scared that the Supreme Court will come up with a technically erroneous decision. I think it will be measured. I think they will understand the issues, the technical issues as well as the legal issues, and they'll come up with a fair decision. At least that's my take on, based on my observations during the oral arguments.
Fantastic. Thank you so much.
Thank
JJ,
you.
we've been speaking with attorney JJ Decini. He's one of the top IP lawyers in the country. His name is on the case that against the cybercrime law that the Supreme Court is now debating. We're waiting for the decision. The outcomes of the Supreme Court decision on the cybercrime law. It is 1 year after petitioners questioned this controversial provisions. You've heard some of his thoughts. Continue the conversation, and we'll watch out for it. I'm Maria Ressa. Thanks for joining us.